Ms. Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on. Listen to me. Everything you have there is overruled. And here's one of the reasons why. Is because you have a lawyer. And your lawyer will file the appropriate motion. You're interrupting me again, which is disrespectful.
And we are 11 seconds in and the judge is already drawing a line in the sand. Quick legal note, overruled means the court has considered the objection or argument and rejected it. Saying respectfully doesn't give you a procedural force field. Courtrooms run on rules, not vibes. Question for you, do you think interruptions help a defendant's case or quietly hurt it?
Water Assistant Public Defender on behalf of Ms. Lathan. Ma'am, would you state your name for the record, please?
I'm not Ms. Lathan, I'm principal. I am J. Ruth Bay, cardholder and principal of Jade Lathan.
Your Honor, I did attempt to...
Mr. Overwater, while she's given that, is this the person that you know to be the individual named in the complaint? If not, we are going to have a problem, and I will have this person, since she got up here, taken into custody. We will do fingerprints and we will determine her identity by our standards. So we can do it one of two ways.
Judge, I don't question that she is physically the person that is alleged to have committed these offenses. What I do believe is that there is an issue as to competency.
For the record, I do not know this man, and I did send him a cease and desist to not represent me. However, thank you, Your Honor. I am the principal and cardholder of Jade, Ruth, and Lathan, and beneficiary.
Very well. Mr. Overwater, you are on this case, so what do you wish?
Here it is, the sovereign citizen identity pivot. This strategy hinges on the idea that there's a real person and a separate legal entity or estate. But in criminal court, identity is about whether you are the human being charged in the complaint. The judge isn't debating metaphysics, he's confirming who's standing in front of him. When a defendant refuses to acknowledge their own name, that's not a loophole, it's a red flag. And watch how fast this turns from philosophy to procedure.
At this point, the issue of competency needs to be raised. So I would ask for a competency evaluation. This matter be set over for a competency hearing.
I'm not
pursuant
asking
to the
for
statute.
anything, and that's, from the horse's mouth.
I'll need an order.
I did turn in my statement of fact so that there's more than the police record on the record. I have not harmed anyone, and the cameras will reflect that if we are to go that far. But I would like to motion to settle.
I don't know what that means.
Well, I want to settle because I'm the card holder in X relation to the principal, and I do not want to be
I have
mistaken.
no idea what you're talking about.
Okay.
That right there is the reality check. If identity can't be confirmed verbally, the court can confirm it physically, fingerprints, records, booking data. Judges are responsible for ensuring the correct person is before the court. This isn't intimidation, it's administrative necessity. Sovereign scripts tend to assume the system will freeze. Instead, the system escalates verification. Fantasy meets fingerprint scanner.
I yield.
Thank you. Forensic evaluation is ordered. I'll order a competency hearing. I'll set that competency hearing for
June 6th.
June 6, 2024, 9 a.m.
6/2020.
At this time, bond will continue. Mr. Overwater, prepare the order, please.
I will do that, Your Honor. Thank you.
Thank you.
Thank you, Your Honor.
Welcome.
Good morning. Are you Janetta Pugh?
I am the beneficiary of the estate.
You're the what?
I am the beneficiary of the estate.
You're the beneficiary of what estate? Answer my questions, please, ma'am. I'm just trying to understand.
Beneficiary of the estate.
Okay. What's the announcement?
Judge, it's my understanding that Ms. Pugh and her family has retained an attorney on this matter. You may I don't know if you remember, Judge, this is when I was originally appointed on, and we were on the trial docket. She hired a new attorney at that point, Mr. Norwood, who was on the case for a while, and then withdrew. And once recently, when the case came back to me, I visited with her and was told that they did retain another attorney. I was given the name of Christopher Wiley this morning, but I have not heard from him. And my understanding is that at this point still hasn't filed anything with the court.
Okay.
But I've been told that that's who's supposed to be taking over the case.
Okay.
For the record, I recognize Ms. Pugh. She's been here before.
I do as well, for the record.
And I looked into Mr. Christopher Wiley. I can't find that person as a practicing lawyer in the state bar page, and I have not been contacted by anybody on Ms. Pugh's behalf.
All right, so Ms. Pugh, Mr. Lewis has been appointed to represent you at this point. Obviously, you know as well as anyone that you're in custody and we want to get your case taken care of. If you've hired or your family has hired another lawyer, then they have to contact the court so that we can do something with your case. And do you know if they've hired someone?
Respectfully, Your Honor, I do not agree with your appointed foreign agents, considering that the first duty is to the state and will be considered conflict of interest.
Okay, so if you don't want, the only thing I can do, I'm appointing an attorney to you to help you, right? So if you don't want a court-appointed attorney, then your only option, two things. One is to represent yourself or to hire a lawyer. So if you don't like the way it works, then you do something different. So are you, listen to what I'm saying. Are you either going to represent yourself, or are you going to let Mr. Lewis represent you, or are you going to hire someone?
Objection, Your Honor. Respectfully, is this a court of record?
It is a court of record. So your objection's overruled.
Okay. Respectfully, Your Honor, where is the verified claim that is being placed against my trust?
It's right here. It's called an indictment. And Mr. Lewis has a copy of it, and he can show it to you. So that would be the verified claim against you.
Okay. Your Honor, respectfully, Your Honor, there were writs that was filed to the case that still haven't been received.
I've received your petition for writ of habeas corpus, and it's denied.
Okay. Respectfully, Your Honor, I demand to be released due to lack of evidence of stated claim and not being given the proper opportunity to obtain proper counsel defective defense.
It's overruled.
Okay.
You're running out, aren't you?
No, it's fine.
So here's the thing, Miss Pugh. I appreciate your position, but listen,
Respectfully, Your Honor,
Miss Pugh, don't
with my
speak over me.
incarceration, respectfully, Your Honor, with my incarceration,
This is a pivotal moment. A competency evaluation isn't punishment, it's a constitutional safeguard. If a defendant appears unable to understand proceedings or assist in their defense, the court must pause. Ironically, tactics meant to assert control can trigger the very mechanism that slows everything down. Think about that. By refusing to engage with basic procedure, she may have delayed her own case significantly. Strategic move or self-sabotage.
Miss Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on, listen to me. Everything you have there is overruled. And here's one of the reasons why, is because you have a lawyer. And your lawyer will file the appropriate motion. You're interrupting me again, which is disrespectful. So I'm going to leave Mr. Lewis as your attorney unless you choose to represent yourself or hire someone else. I'm going to give you 2 weeks to determine what you're going to do. You can go back. You can go back with the bailiff.
I do not agree or comply to your appointed
Go back.
agents.
You already said that, and that's overruled.
Is to the state.
And that's the mic drop moment. An indictment is the verified claim. It's issued by a grand jury and formally accuses someone of a crime. There's no separate trust document, no secret commercial filing that overrides it. Criminal law isn't a contract dispute you can settle by redefining terms. When the judge says it's an indictment, he's grounding the conversation back in actual law. No mythology, just procedure.
Go back with the bailiff. Get your own attorney or represent yourself if you don't like it.